Hi, my name is Aaron Lacey. I'm the co-chair of the higher education practice at Thompson Coburn LLP, and you are listening to the HigherEdReg Rundown. This is our latest edition, which focuses on the latest guidance from the U.S. Department of Education relating to their financial value transparency and gainful employment rule. Thompson Coburn, if you don't know us, is a large national law firm with offices around the country, and we have a higher education practice, which means we have a group of attorneys who spend all or most of their time serving institutions of higher education. And the purpose of this particular series, the HigherEdReg Rundown, is to try to highlight a topic of particular interest or that's particularly important for the community, and to do it in 10 to 15 minutes as opposed to a longer webinar format. Today, I'm going to be joined by my colleague, Hope Watson. You'll hear from her in just a few minutes as she talks about some important concepts. But first, I wanted to start with just a little background and then talking about the elephant in the room, or at least what I would consider the elephant in the room, which is litigation. So the Financial Value Transparency and Gainful Employment Rule was issued in final form in the Federal Register on October 10th, 2023 by the U.S. Department of Education. It took effect on July 1st of 2024, and the department over the last few months, continuing right up until just yesterday, continues to issue really significant guidance around this rule. The best place to probably find that guidance is on the Financial Value Transparency and Gainful Employment Topics page. And I'll just note, if you go to our Higher Ed resources page, and I'll give you a QR code later in the presentation that you can follow to get there, you'll find not only this video, but also the PDF of the slides. And if you download that PDF and go to these links, you can click on them and it'll take you to the linked resources. But let's talk about litigation, because you may be saying, well, Aaron, why should I care about all of this guidance? Isn't there a lawsuit out there? Am I even going to have to comply with this gainful employment financial value transparency rule in the first place? And the answer is right now we think yes. And let me tell you why. So in December of 2023, the American Association of Cosmetology Schools filed a lawsuit in the U.S. District Court for the Northern District of Texas, challenging the new financial value transparency and gainful employment rule, and generally arguing that it was either violating the Constitution or the Administrative Procedures Act, etc. A lot of arguments that were made, as you would expect in that complaint. And shortly thereafter, in March of 2024, another lawsuit was filed by Ogle School Management and others, also in the U.S. District Court for the Northern District of Texas. And this latter suit specifically was seeking a preliminary injunction of the rule to keep it from going into effect on its July 1st effective date. Now, on June 20th, the court declined to grant a preliminary injunction, and I quote, "Plaintiffs have not met their burden to justify an extraordinary remedy of injunctive relief at this stage." And I do want to take just a moment to pause and say it's important to note that a preliminary injunction is an extraordinary remedy. It's a really high bar. Among other things, plaintiffs have to show that the court has to find that there's a likelihood of irreparable harm to the plaintiffs. Also, that there's a likelihood that the plaintiffs would be successful on the merits of the case once it's actually considered. And that's hard to show in the context of gainful employment in particular, because you don't yet have the calculations and you don't have any evidence, or at least verifiable evidence, that you're going to fail and be sanctioned down the line. So there are a lot of reasons it's challenging to obtain a preliminary injunction, particularly in the context of this rule. But I also want to highlight this rule there's been a lawsuit challenging the prior two versions of this rule. And in the first version, no preliminary injunction was granted. But ultimately, the court did find that elements of the rule violated the Administrative Procedures Act, and a great deal of it was rescinded. And then the second time, the court had already granted the second time, the court did not grant a preliminary injunction. But again, when considering the merits, was taking serious issue with components, particularly the actual earnings component of the rule. Ultimately, that litigation didn't end up playing out because the rule was rescinded by the Trump administration. But the point here is, in both of the prior litigations, there was no preliminary injunction granted. And in both of the prior litigations, ultimately, the department was expressing or did express, the court was expressing or did express serious concerns with the rule. So we still think there are a lot of reasons to believe that the plaintiffs ultimately could prevail here. Chief among them, by the way, is the fact that we now have the Loper Bright decision from the Supreme Court. So in addition to all the sort of concerns with the mechanics and things that were raised on the prior two versions of the rule, in this litigation, once again, plaintiffs are arguing that, among other things, just the whole concept, the gainful employment financial value transparency framework, exceeds the department's statutory authority, meaning that Congress didn't give them the authority to go out and create this thing in the first place. Now, the first two times there was litigation, this argument was made, and the court said, well, okay, we think that fundamentally the department does have the authority to create something like this. but that was under the old Chevron standard. Loper Bright came along and has upended the Chevron standard and replaced it with a new standard. Specifically, now agencies under Loper Bright can only issue regulations that are not only reasonable, but are consistent with the plain language of the statute. This is a paraphrase, but the concept here is important to understand. It basically means that courts are going to be reviewing agency rules and regulations very closely to determine, and more closely than under Chevron with less discretion, to determine whether they think Congress really authorized the agency to create the rule. And here we think under Loper Bright, there's a real possibility the court may find that the entire gainful employment framework exceeds the department's statutory authority that was granted it by Congress. So lots of reasons to believe that this litigation, or specifically the plaintiffs in this litigation, could prevail, that the GE rule might be struck down, but we do not anticipate seeing anything along those lines until spring of 2025, given the briefing schedule. So what that means is, in the interim, institutions do need to plan to comply with those elements of the rule and those obligations that will occur between now and then. So specifically, we think institutions should be monitoring the completers list developments. We're going to talk about that here in just a second. I'm going to kick it to Hope. Deciding between standard and transitional reporting, and preparing to report their data. So with all of that said, I'm going to kick it to Hope to start us off on the completers list.
Thank you, Aaron. So as Aaron pointed out, we're looking at three buckets here, and we're looking at three buckets, three areas of focus. And the first area of focus we're going to talk about is these draft completers lists. So the department sent these out to institutions on August 8th of 2024, and those would have shown up in your SAIG mailbox. Now, I want to note that the department sent out an initial version of the draft completers list on August 6th. The department has since put out an announcement that there may have been some errors with that list, and so they're now asking institutions to refer exclusively to that August 8th list and to get rid of the August 6th list. And as a reminder, those completers lists are going to identify relevant students who completed either a GE or eligible non-GE program during the 2-year cohort period. So that's 2017 through 18 and 2018 through 19, or the 4-year cohort period, and that's the years ranging from 2015 all the way to 2019, and that's specific to the 2022 earnings year.
And I'll just jump in here quickly to make a couple of points on completers list timing, which, among other things, really evidences how quickly and regularly guidance is coming out and how much the landscape is changing around reporting and a lot of these sort of concepts related to this rule. So institutions initially were advised that they had until October 7th, 2024 to add or remove students from the completers list and to get that information back to the department. The notion being that the department would then take those final completers lists, send that over to the IRS to pull the earnings data that's going to be used in the calculation of the DE rates and earnings premium calculations. However, yesterday, we're recording on August 31st. So yesterday on August 30th, the U.S. Department of Education announced, quote, newly identified issues with the completers list and the financial value transparency and GE reports that they had been providing, right? And this is the important point. Please note, again, I'm quoting, we suggest institutions pause reviews of the completers list and use of the financial value transparency and GE reports as we, meaning the department, works to resolve these issues. We will notify the community with an update to the once these issues have been resolved, and we will review the related reporting deadlines. So it's incredibly important to note, if we had recorded this a week ago, we would have been telling you, you need to get through those completers lists. You need to be reviewing all of this and responding to the U.S. Department of Education in preparation for the October deadline. But now, please be aware that the department has asked institutions, has suggested that you put your review of the completers lists on pause because the data that they've been providing and the list they think may have significant issues, and they're going to be coming back to you potentially with revised deadlines. And if the completers lists are pushed back, we anticipate it could mean that these other data reporting deadlines are pushed back. But there is nothing right now, this is also an equally important point, to suggest that you will not ultimately have an obligation to review and respond on the completers list or to provide the data. In fact, and I want to emphasize this point too, the data reporting deadline, right, in October 1st to supply not the completers list, but your data in general has not yet been moved. So critically important to stay on top of that. And with that, I'm going to kick it back to Hope.
So the second area of focus is the reporting itself. So reporting is now underway and it has been since July 1st of 2024. Institutions are now able to report all of that student-specific and program-specific data that the department is requesting under this new rule through the department system, and institutions have until October 1 to make sure all of that information is reported. Now, you may recall initially seeing a deadline for that data on July 31st of 2024, but the department has since extended that deadline. So to be clear, all of it is due by October 1, 2024. Now, we recognize that these reporting requirements are extensive and may even seem overwhelming. And the department possibly thinks so too, because the department has put out a lot of resources on this topic. And I want to highlight a few of those for your reference. So the first I'll highlight is 3 reports that the department has published, NSLDS reports, and the stated purpose for these reports is to help institutions identify both the students and the programs that are going to require reporting under the new rule. And these reports were generated based on the information already provided to NSLDS via your normal institutional enrollment reporting process. I also want to highlight here again the NSLDS user guide. We have so far volumes 1 through 3 of that guide, and we're anticipating a 4th volume. So volume 1 covers the student-specific reporting, and this goes into a tremendous amount of detail about the student-specific component of the reporting requirements, and it talks about this process on a very granular level, to the point of talking about each individual data entry that you'll have to make. Likewise, volume 2 talks about the program-specific data that you'll be reporting at a similarly granular level. And then volume 3 is going to go into a lot of detail about how to actually go through the process of making corrections to your completers list. Like I said, we're anticipating that volume 4 to come out at some point in the near future, and the department has indicated that volume 4 is going to cover how the department is actually going to calculate those debt to earnings metrics and the earnings premium, and to give institutions some more sort of behind the scenes insight into that process. Lastly, I want to highlight the frequently asked questions page of the department's new rule topics page. And in particular, relative to the reporting, I want to highlight the reporting specific section of those frequently asked questions. So these get into hypothetical situations that an institution may be experiencing as they work through the reporting process, and give insight into how to approach and resolve those hypotheticals. So consider that checking that out. And then lastly, though it's not listed here on the slides, I want to call your attention to one other resource that's going to be embedded within the user guide, and it's information on determining whether you want to use the batch process for submission or the spreadsheet process for submission. And the department has indicated in some of their guidance that they think that the spreadsheet is going to be probably the most approachable and easy to use version for schools. And there may be some limited exceptions where you would use batch reporting, but good to take a close look at that and consider what is best suited for your institution.
And I'll jump in here again just to say quickly, we recognize, as we just mentioned earlier, in the August 30 guidance, the department suggested that institutions pause use of the NSLDS reports. but we still think it's worth being familiar with those reports and sort of how they're laid out, particularly if you've not even looked at them yet, because we anticipate you'll probably get an updated version. And there has been no suggestion from the department that institutions should pause review of the NSLDS user guide or of their fact page. In fact, there's a lot there, and we recommend, again, that institutions, particularly if you've not even started, really begin reviewing this material. And if you have been working on the reporting, it's good to be reviewing and revisiting these resources regularly, because the department is putting out a lot of updates.
In addition to determining whether you're going to use batch or the spreadsheet version in terms of your reporting method, you also have to make a determination about whether you're going to do standard versus transitional reporting. And you will make that determination this very first time that you're reporting data under the new rule. And it's important to note that this determination is something you're going to make initially, and you can't change it once you've made that choice. The other important thing to note on this topic is that you're making this determination for the entire institution. So it's not a program by program consideration, it's for your whole school. Now, schools that choose transitional reporting will use that reporting method for the first 6 years that the regulations are in effect. And by contrast, schools that choose standard reporting will be expected to provide data for all the years during the cohort period. I'm going to give a little more detail about what I mean by that. So here on your screen, you have a chart. This is the department's own chart that they've published in guidance to this rule. And as you'll see on this chart, if you choose standard reporting, in the best case scenario, you're going to be reporting data for 7 years. And if you happen to have a qualifying graduate program or two, you'll be reporting data for 8 years. For the transitional reporting, you're just reporting data for 2 years. So looking at this chart, it's pretty plain to see that one of the big differences between standard and transitional, and perhaps the most important difference, is that standard is going to have a much higher reporting burden on the front end. But there are other considerations here too. So when you're weighing the options, in addition to thinking through the higher reporting burden, we also want to note that if you choose standard reporting, you have no ability to impact cost or debt data for years. That data is baked in. And to kind of illustrate what I mean by that, the department is going to be using debt and cost data for this first round of calculations under the standard reporting option, dating all the way back to the 2017-2018 award year. So there's nothing that you can do to change what happened back in 2017 or 2017-2018 for your cost and debt data. By contrast, with transitional reporting, the department is going to look at the 2 most recent years, and so that's 2022-23. That data is already baked in. Nothing we can do to change that because those years have already happened. But for the following year, they're going to look at 24-25, and that year is underway now. So we have a small opportunity here to potentially impact rates through that debt and cost information if you choose transitional reporting.
And Hope, I'll just take a minute here to jump in and say, if folks are having trouble wrapping their brain around this idea, the difference between the standard reporting frameworks and the traditional reporting frameworks, and why it matters, if you check out our desk guide on gainful employment, which we're going to reference here in a minute, there's some really nice charts in there that can help you sort of visualize the years that are going to be reported, not unlike the chart you just saw from the department, but more specifically created for this purpose of helping you understand sort of the cohort periods and why this idea of choosing the standard reporting cohort is going to lock you in and make it impossible to impact your rates for 6 years to come.
Yes, Erin, that's a great point. Thank you for that. And to sort of wrap up here with the third thought you see on your screen, the one scenario that we can imagine an institution choosing standard over transitional would be in the limited circumstances where you've had a drastic increase in program cost in the past few years. And the idea here is that if in your prior years that program was significantly less expensive, your debt and cost information is going to be better, and that may give you a period of buffer before the debt and cost information from recent years catches up. And during that buffer period, you may be able to put out new programs. You may be able to teach out programs that may potentially have metrics issues. And so it allows you more time to do some of that planning in the event that you've had that big change in price for your programs. But under all other circumstances, we're anticipating that most institutions are going to choose transitional for the reasons we've discussed here. And with that, I'm going to turn it back over to Aaron.
All right, thank you, ma'am. And with that, I'll take us home. So here on your screen, you see our higher education resources page. Promised earlier, if you look at the QR code right there, you can scan that and it will take you directly to the page, or you can just Google, Thompson Coburn Higher Education and find your way there. We got smart a couple of years ago, and we put all of our resources that we create for you all on this one page. So that's our white papers, that's our webinars, our higher ed reg rundowns, anything that we're generating that we think is helpful for the community we have in this one place. And that includes the slides, again, for this presentation. It also includes our financial value transparency and gainful employment desk guide, where we break down the rule and in particular provide you sort of with step-by-step instructions if you want to try to sort of project what your rates might look like. And then finally, we also did last December, I think it was something like 4 hours total of webinars reviewing the rule and sort of really getting into the weeds on a lot of these aspects. If you are someone who's newer to it and would like to go back and just get a better understanding of what this thing is all about. Lastly, here's our disclaimer. We're not your attorneys unless we're your attorneys, in which case we're grateful for the opportunity. And until next time, be well.